My name is Kiati, I'm head of Joshi Advocates. Thank you very much for joining us in this video. Detained in the UK and making a bail application in the Immigration Tribunal. What are the considerations the judge has in mind? So there are 6 and we're going to run through them in the next 5 minutes. The first is the immigration history. What is the detainee's immigration history like? So whether they came in legally, whether they have overstayed, how long they've overstayed, what is their background in terms of the immigration matter. 1. The second is character. Has the detainee lied to the Home Office previously or have any criminal convictions? So that is also a factor. Home Office would say easily that, oh, this person has lied to the Home Office previously by giving a false document, or has a criminal conviction, or has failed to comply with the previous reporting conditions. So this person should not be trusted to be released. So that's how the Home Office will deal with it. So that's a key consideration to bear in mind. The third is the removal imminent? So where there is a removal direction, Home Office has said on this day, on this plane, at this time, the ticket is here, here's removal direction, then the removal would be imminent. Aside from that, removal is not considered imminent. Now, how else can we determine whether removal is imminent? So say a person has an application pending or any court cases pending awaiting a decision, which would mean that the Home Office cannot set a removal. Therefore, removal is not imminent. Another matter that arises usually is where the Home Office is uncertain as to the nationality and therefore unable to obtain a travel document from the relevant High Commission or embassy. So that's another factor. Then the judge would think, okay, even if removal is not imminent, say this person has something pending in the court or the Home Office, is detention necessary in the public interest? Are there alternatives to detention? So the detainee applicant would show that no, detention is not necessary because A, it's the last resort, and B, there are alternatives such as reporting conditions, residence requirement, even an electronic monitoring tag, just so the judge can be confident that this person would not abscond if released on bail with reporting conditions, for example. So there are alternatives to detention, and these must be highlighted. Right. And then sureties. This would again strengthen the bail application where other people are coming to court showing their bank statements. Keep in mind, just showing their bank statements. Nobody has to actually pay money to the court. It's just to show the judge that, look, money is available and it's proposed to the court in X sum. And I can even show where the monies come from by way of pay slips or self-employment documents such as a tax return or an accountant's letter. So therefore, the money is mine and it's in my bank statement, and I'm going to propose it to the court. So if the applicant detainee runs away, absconds, then the court can take the money away from me. So if the sureties come to court with these documents and their ID, just note here that the sureties must also be of good character, because if they have previously breached immigration rules or they themselves have criminal convictions, it doesn't bode well with the judge in giving the application enough weight. So that's one. Here, where the surety is coming to court, they would not have to propose a minimum number. There is no minimum number, but reasonably speaking, the more proposed to the court, the more confidence the judge would have, i.e., for example, the judge would think, well, this person is proposing a lot of money. They must have a lot of confidence in the applicant complying with any bail conditions the court may deem fit on granting bail. So that's great. Also, what would be good is address. So if the judge is thinking, okay, look, these people would propose money to the court, but I don't know if I can release the applicant to an address because the landlord may not have given permission for the applicant to even live there. So here's where we want a letter from the landlord or even a tenancy agreement, if possible, in the detainee's name, confirming that this person is allowed to live at that address. Now, those are the 6 points we have gone through, and the documents required side by side. Just keep in mind that if the bail application is not made with all these factors taken into account, the judge at court may indicate that, look, come back with these documents and withdraw your application. Why the judge is doing that is because if the bail application is refused, the detainee cannot make another bail application until 28 days from the date of that first bail application decision. And even a subsequent bail application is made, that application will be shadowed by the previous bail refusal. So when you make a bail application, make it properly with all the documentary evidence assessed and available on the day of the hearing. Right, final thing I wanted to make a note of is, say there's removal direction and the bail hearing is heard on the day. The judge would not have the power to grant bail. What I mean is, say there's a removal on the 14th of a month, and the bail hearing is on the 1st of that month. So the bail hearing is on the 1st, and the removal is on the 14th, 14 days later. The Home Office will have to give permission to the judge for the detainee to be released. The judge does not have the power alone to release a person on bail, even if everything else is met. Just keep that in mind. Thank you so much for joining. As always, subscribe, contact details below, and I'll see you next week.